Great, good morning, everybody. I'll call the meeting to order, and the first item on our agenda is the approval of minutes from September 20th. Have a motion to approve? Second. All in favor?
Aye.
Great, those are adopted. We next get an update, a report on updating the caseload standard in defense representation. Nora Christensen. Yep.
No, Patricia wanted to say anything first. Good morning, everyone. It's nice to see you all here. So I wanted to give you an update on where we are and what our plans are on updating our criminal caseload standards. But I also thought it might be helpful first just to give a very brief overview of how we got to where we are right now. And I know some of you lived it, but for those of you who didn't, I thought it might be helpful just to kind of hear where we got to and why we're making the decisions we are right now. So the current caseload standards that we have for criminal defense representation are really the product of the Harrell Herring settlement. And prior to that, we were really reliant on what a lot of people across the nation have really been relying on, which were sort of these standards called they were created by the National Advisory Committee on Criminal Justice Standards and Goals, the NAC standards, right? And those standards were not really the product of any sort of empirical research or scientific study or evidence-driven standards at all, but rather they were really the product of what everyone can gather is sort of a discussion that happened amongst some defenders that produced the standards. But nevertheless, they were really used and they continue to be used because there was a lack of any other criminal caseload standards anywhere really in the nation. And so people needed something, and that was something to really rely on. And of course, this board approved ILS to use a modified version of that standard prior to the Harrell Herring criminal standards were issued. So when it came time for us to create standards based on the settlement and as the settlement directed, we really realized that we wanted to do it in a way that was evidence-driven and that had some sort of empirical background to it. And so we worked with the parties to the settlement to get permission to extend the settlement, as some of you may remember. We were able to then conduct a caseload study with the RAND Corporation. And so we did that in 2016. And our caseload study was 3 phases. It was first a phase of time tracking where defenders in the 5 settlement counties tracked their time on certain case activities or certain case types for a period of time. The second phase was a time sufficiency survey where the information received from the time tracking part of the study was then sort of fed back to defenders in the 5 counties to comment on whether or not the time that was recorded was sufficient for the case activities and the types. And then finally, we convened a Delphi panel, and the Delphi panel of experts in the field, right? So people who had expertise and experience in quality criminal defense. And they came together for a day to come to consensus on what the average amount of time should take to be on the certain case activities that we had highlighted throughout the study, and at that point in our 7 different case types. So from that information, and because the caseload standards were really directed and driven by the Harrell Herring settlement, we were also under the obligation in the settlement to consult with the various parties, the counties, various other stakeholders who were involved in it, and the executive to ensure that whatever standards we were issuing could be funded and fully funded so that they could be implemented. And so we took the information from the study that we did, we took information from the consultations that we did, and we produced what has been our criminal caseload standards and issued them in 2016. Since then, a lot has happened. We've had a lot of time to implement them. I know I have quite a few people at this table right now who are still in the process of working to implement them. We've learned a lot throughout the 7 years of implementation. And frankly, even with everything that's been occurring, we've always known since we issued them that there would be a need to continually evaluate and update the standards. That was actually in the settlement. It was required by the settlement that we do that. But we also knew that because whenever you issue standards or anything of the type, you have to have the ability to implement and then evaluate to ensure their effectiveness. And so we've been committed to that, and we've been doing that. Of course, in the meantime as well, we have had rapid advances in technology. And even in our caseload report in 2016, we acknowledged that practice had changed so significantly that it was important that we have these sort of more progressive criminal caseload standards. But even since then, the sort of rapid development in technology has been, and I think people here probably could speak to it better than me, but has been very impactful on the amount of time that people have had to spend on their cases. Of course, the 2020 or the 2019 changes to the discovery laws were, a watershed moment for the defense, but also, as we learned in our discovery survey that we did, NISA and others, that while it certainly was a much needed change to the rules and certainly has brought the defense practice sort of into the modern times, it's also resulted in an incredible amount of information that requires additional time spent on cases. There have been significant changes to post-conviction practice and the right to counsel in post-conviction practice. And frankly, even since we issued our caseload standards in 2016, there have also been many other jurisdictions across the nation who conducted their own caseload studies. And so when we issued our standards, we could only really look to a handful of other places that had conducted these types of studies that were rigorous data collection and coming up with a result of an evidence-based driven standard. Now, many more jurisdictions have done it. And in fact, that led a lot of the different organizations who had been conducting those studies to sort of come together and look at all of the data that have been created from 17 different caseload studies throughout the nation and really come together and do a national Delphi panel to produce the first national evidence-driven standards. And so that was really what we call sort of the National Public Defense Workload Standards. It was the product of the RAND Corporation, the National Center for State Courts, the American Bar Association Standing Committee on Legal Aid and Indigent Defense, and an attorney, Steve Hamlin, who's been really active in caseload standards trial. They had 33 participants on their Delphi panel. They went through a series of sort of what the iterative process that is typical of a Delphi panel. And they released these recommendations for national workload standards in 2023. With that release, they were very clear that these are evidence-driven, they are recommendations, but that it is imperative that jurisdictions figure out how to apply them locally. And because the factors can vary substantially from jurisdiction to jurisdiction, the most accurate weighted caseload model has to be developed for any individual state or jurisdiction. And we took that very seriously when we read that as well. The other piece that has happened since then as well is the American Bar Association revised the 10 principles of public defense. And principle 3, which is in your packet and in your materials, really calls upon states to review their current caseload standards and ensure that the jurisdiction-specific workload standards are employed and developed appropriately, but that national workload standards should never be exceeded. And in that, they cite to this new National Public Defense Workload Study. So all of these things are sort of swirling around. We've seen a lot of changes. And so, we felt that it was appropriate and necessary for us to really take this information and think about how it relates to our current caseload standards, how it implicates New York practice, and what we should be doing about that. So we took the first step of mapping the national standards to our current criminal standards. It's difficult, right? Because they had different caseload categories. We have our own caseload categories. Everyone has specific definitions of specific crimes and where they will fit. But we had a diligent group who really did the work and really did the research to try to map that. You have that in your materials as well, sort of the result of that mapping. And we had the opportunity to not just do that internally, but we worked with our Chief Defenders Advisory Group to really get input on what belonged where and why and how it should look. I note that one of the things that we included in our mapping that's not included in our current caseload standards is sort of homicide, life sentence possible category. Frankly, even before the 2019 reforms to the criminal justice laws, we really knew that there were certain things that we needed to update in our standards. And one of them was that we were not sufficiently sort of discerning when it came to the distinction between homicide representation and other violent felony representation. So that's something that we sort of had our, we were focused on anyway, and we heard from the Chief Defenders Advisory Group that was something that was very necessary. And we've certainly heard it, frankly, from defenders across the state for years. The other thing, by the way, that we have always sort of been focusing on since we began implementing these standards is our appeals standards. Right now, we only have two categories of appeals of a verdict and appeals of a guilty plea or of a sentence, or of a guilty plea, excuse me. And we've been in touch with the appellate providers throughout the state for many years about this because we have always thought that they needed to be a little bit more discerning, and there may be a way to capture the appellate better than the way that we did in those two standards. And so that's another place that we've really been, focused on for quite some time, and we wanted to make sure that we were really honoring that and understanding the appellate practice. So we knew that there was a need to update the standards with all of these things that we've heard. But we have struggled with when the right time to do it is. I think it is no secret that with the challenges in recruitment and retention that everyone's been experiencing, particularly since COVID, it has been incredibly challenging for a lot of our public defense providers across the state to actually fill the positions that are already available under the current caseload standards. And there are a myriad of other reasons that has been challenging for people to kind of create and fill those positions. And we still have a number of providers statewide who are working to sort of come into compliance with the current standards. And so we wanted to make sure that whenever we made the decision to do this, we weren't doing it just by changing the goalpost and that was that. So we're really trying to take a very thoughtful and deliberate approach in how we do it. At the same time, because of the ABA standard, the ABA 10 principles, the national standards, and there is an opportunity to ensure that we are updating our standards to credibly reflect the modern practice and defenders practice, and to give providers in their local jurisdictions the opportunity to advocate for what their needs are with their local jurisdictions as well. We decided that this is the right time for us to do it. However, anything that we update, of course, will have to be sort of contingent on ensuring that we have the adequate funds and the ability to actually implement them. And of course, we know that it's a process. Just like when we began to implement the 2016 standards and our current standards, even then we recognized it was a process. With the Harrell Herring settlement counties, we projected a 2-year sort of ramp up to meet caseload standards, which they were able to do. And with the rest of the extension statewide, based on the nature of the funding and the phase-in, we really suggested it would take a good 5 years with the phase-in. And frankly, as again, many people know who are sitting at this table, even by getting to the 5th or 6th year of the statewide funding was really the first time that everyone had the full amount of funding and their full plan on how to even meet caseload standards. And then, of course, having to actually get it done, right, which is hiring the people, getting through your county bureaucratic processes to create the positions and all of the things that go along with having to actually staff up. So we understand it's a process, and we understand that whatever we do in terms of an update will be, will necessarily have to depend on the availability of funding. However, I think in order to ensure continued credibility with our standards and to ensure that our standards are reflective of the current and modern practice, we want to ensure that we're doing it now. So very briefly, what's the plan? We are deep in the process already. We had a meeting with the Chief Defenders Advisory Group to discuss what the process should be. We frankly could have just stopped with mapping the national standards onto the ILS standards. But I think everybody agreed that it was really imperative that we have something that was New York specific and that reflects New York practice, and that people from New York have the opportunity to really reflect on what that means. So we are going to convene another Delphi panel. In fact, we're going to do 2 Delphi panels. One we'll do for the trial level practice, and then we're splitting off our appellate level practice to do a separate appeals Delphi panel. So we'll bring together 2 different panels of experts to discuss these different case types. As you can see from your materials, we're also updating the case type slightly to sort of a more discerning number of case types. There's 10 now from our current 7. And in the meantime, too, we are information gathering. So one of the things that we know, and that I've just talked about, and everybody here knows, is how impactful the discovery reforms have been on the practice. And so we thought it was really essential that we do a survey of defenders to see how it has impacted their time, what types of things they're using to help them review discovery and how that's impacting their time, and any of the other information that might be relevant to thinking about how someone is spending time reviewing discovery and or otherwise on their case tasks. So we're in the middle of that. I think that closes December 23rd, the survey. We're also in the middle of identifying members for our Delphi panels, looking to people who are experts in the field, people who are well respected, people who you would turn to if your loved one was arrested and you wanted representation. And so we are seeking input on that right now, and we'll hopefully have a Delphi panel for both the trial level and for the appellate level soon. And then we anticipate the work to really be in the early part of the year. So between January and sort of April, probably we will be doing the trial level updates at that time, with the hope of being able to present the board the new standards to review at the June meeting. With regard to the appeals standards, we have to do a little bit additional data gathering from some of the appeals providers, and we're also in the process of doing some of the other things that I discussed. And so we're hoping to do the appeals standards close in time to the trial level standards, but we are also trying to be mindful of what is needed and make sure that we're doing it well and a thoughtful process. So we'll keep you posted on that. And I think that's everything I have. If anyone has any questions.
What's the child level age? What's the age?
The child level.
Trial.
Oh, trial.
Trial.
That's child level.
Oh, no, it's interesting actually, because nobody has done any juvenile standards in that way. I mean, obviously there are some AFC standards, but it's different. Yeah.
Well, I was just glad to see the distinction with the A felonies and the A sex offenses
Yeah.
and things like that. And I'm wondering, because a lot of places have positions with mixed caseloads because they can't really afford to have someone who's just designated for, say, the A felonies. Are you looking at weighting the kinds of felony? Okay.
Yeah. So we currently do that, and we'll continue to do that. Basically, we always, right now, the way it works is, we have the 7 different standards, and our misdemeanors are no more than 300 annual new assignments per year. So we weight everything to the 300, so that the misdemeanors are a 1 and the violent felonies are a 6. So if someone has a mixed caseload, we do that calculation.
I have one other question. Sure. And that was, or maybe it's just a comment. You talked about the recruiting issue, and I saw something, I think, in materials about trying to start an elementary school. But I wonder if ILS or could create regional positions or something within ILS that was a headhunting position or regional recruiters for different areas of the state, and really focus on, because that's so much a part of all of this. It's how do we get people here, but professionals who know how to recruit.
Yeah, I mean, that's, that's not a bad idea, but we also fortunately have the New York State Defenders Association actually has some funding for a recruitment project. So they're working hard on recruiting. And so, I think there's, I think you hit the nail on the head. This is an effort that, it's not just one person, not one entity. So, NICE is doing work, and then our regional point attorneys are also working with providers on recruiting strategies. So you heard last meeting from Ian Harrington about the project that he has with Buffalo Law School to create, a forum in the law school, a class that exposes students while they're still in law school to public defense and to the providers in that region who are hiring. So I think it's going to be a multifaceted effort. But yeah, we do work with, our counties on funding for recruiting and things like that. But we're really excited about NICE's project. And Susan, I don't know if you want to.
Sure. Thank you for the opportunity to sit here quietly. So yes, we hired a director of recruitment and retention who started September 23rd. And Isabel Ramos is her name, and she is up and running. And in fact, yesterday we had a 3-hour meeting for chief defenders and others that do recruiting and retention work with 3 panels that included actually Piali, who's here today, from Neighborhood Defender Service Harlem, as well as people from Buffalo Law School, Columbia, Fordham, and Northeastern. And they talked about recruitment issues and retention issues and the schedule for, because so many people are not used to what the schedule is and when to be looking for interns and which year of law school and things like that. And we've got all sorts of plans and during the 3 hours, I was writing down notes, different things. But Isabel's up and running, and Kiara Coleman, who is our legal assistant, has been helping her. And it's a really exciting project. We've been trying to get the funding for years and we finally got it. So, you know, it's not a panacea, but it's going to, I hope, make an impact for the future and current, as well as for not only attorneys, but ultimately investigators, social workers, and mediation specialists. That's our ultimate goal, is to really educate people about the different opportunities that are available. And I believe at the Legal Aid Society, they're currently hiring people to be discovery specialists with the eye towards having them go to law school. So, and that's a number of people, including our deputy director, were investigators before they went to law school. So those are opportunities that we want to seize. And so we're very excited.
I have a question. Are the internships paid positions or are they?
It varies. It's certainly something that is encouraged, and that was actually part of the conversation yesterday as to being competitive. I think sometimes if you're doing it for credit, helping people with housing, if it's not where they are, is something, actually creative ideas have been coming up as to what to do. We learned yesterday that the Queen's DA's office actually worked with St. John's Law School, my alma mater, to have housing for their interns for a semester. So to be able to attract people, and particularly to our rural counties and places that they've never been before, it's incredibly important that we educate them about the area and then get them there, even for a shorter period of time than a full semester-long internship. They have week-long, spring break, and they'll come to a public defender office. So there's different opportunities, and I think that we're connecting with all the right.
I will say too that a lot of counties have really started to try to effectively use the Harrell Herring settlement and statewide funding to pay interns. And we've really been very supportive of that. And in fact, recently I went through and sort of identified who didn't have an intern line, and I was like, okay, we got to get him one. Because I think it's so important to ensure that there's funding available to pay them. And I mean, obviously, housing would be great too. But to the extent that we can use our funding to support it, we do.
I understand that there's still a lot of work to be done and you've got Delphi panels that need to be convened, but can you talk to us a little bit about the order of magnitude of revision to the caseload standards you think you're going to? Is it along the lines of what's in the handout in terms of less than 50% of the current caseloads?
It's hard to say, obviously, what will come out of the Delphi panel. I would expect that we will see something that is closer to the national standards than what our current standards promote. And I understand that sort of could be like that's a big number, right?
It's huge, and I
yeah.
guess that all I would say is, and I know it's ILS's problem, it's ours at the county level. You're really going to run into space issues.
Yeah.
And I mean, so when we talk about the pace of implementation, I think recruitment and retention are huge issues that I don't know how we overcome in the more rural parts of the county, frankly, or in the more rural parts of the state. But the other thing you're going to bump up against, and I know it's our situation in many other rural counties, is there's no room at the end. Like, we don't have enough room for our current attorneys. And if you look at doubling the staff and then doubling the support staff, I have no idea where we're gonna put them.
Yeah.
And we're just gonna have to have those conversations and build that into the implementation timeline in terms of it won't be as simple as just trying to recruit people.
Yeah.
It's gonna be, there's gonna be a capital component to this. And what I always tell my board is it's 10 years from the time you have an idea until you cut the ribbon on a building. So
I have to
we just
tell
need to
you,
have those conversations.
Chris, I learned a lot of that from you back in Washington County. I did, because I was thinking about that a lot, because the one thing I will say that's different from when we issued the 2015 standards is we have the benefit of doing this for the last 7+ years, including working with you in 2 counties, Chris. But I learned a lot of that, and I think our whole office did, and our whole, we did really a job. We always knew it was a process, but I think even sort of those particular issues, I can't say we did it, but I didn't really understand the magnitude of how long it can take to get something done. And I think we have that benefit now of at least understanding a little bit more, having worked with the county so much closer on these particular issues, that I would say that no matter what plans we come up with and what recommendations we make, they would have to sort of understand that it really is going to be a process. And the process, of course, is not just hiring people, because you can hire lots of people, but if you don't have anywhere to put them, that's obviously a huge problem. And I know, many counties are still sort of facing that right now, and, we're aware of that as well.
Thank you, and I do have faith in the ILS staff that we can make this an ongoing conversation. I think the other thing that I go instantly to is I've had conversations with 2 public defenders in my career about, as their offices have grown under the settlement, moving them from a practicing partner to a managing partner, and that sometimes being a difficult transition. And if we talk about expanding the number of public defenders roughly by 2, I think we're gonna have to work really hard with counties to have that mindset shift and start to put in kind of mentoring and more of an administrative and supervisory framework in place within departments. And I will say, most county boards are not overly wild about that. They look at folks like me that sit in a suit all day and just administer things as useless, right? So we need to convince legislative boards and administrators that putting in a mentoring, advisory, administrative framework within these larger departments is going to be really necessary, because I think in the rural counties, what we're going to end up with is a lot of very young attorneys. And we're going to need to cultivate them once they come out of law school. And that's going to take a ton of time from more senior staff. And right now, we are not set up well to do that. And I don't think most rural counties.
I think that's a really important point. It's something that, we have thought a lot about as well, but I think that's a really, that will have to be.
We've talked internally about this and with our chief defender advisory group, but the issuance and approval of these caseload standards, once they're developed by the board, does need to come along with strong messaging about their implications and about what is needed to implement them. And, one thing, of course, is the funding from the state. Second thing is, I think you touched upon, and Laura touched upon, time. And that, I think you're mentioning the third, which is, the sort of mentoring of leadership. But, and I think all of that's going to be important because, with implementing the caseload standards for the settlement, there were some deadlines. And I think that, we found that was hard. And here, I think is exactly what Nora said, that what we've learned from that is we need to be more thoughtful about what is possible and timeframes and support, and making sure that this can happen, but that there's not a sense that, people are not doing a good job if they're not doing it by tomorrow, right? So that's part of what, when we come to you in June with our updated caseload standards, we will come with a draft message, from this board about what they mean.
Anything else on this? Okay. On to our special guests, and I'll introduce them for us.
Great, thank you. So this is, I always enjoy the December meeting the most because it's an opportunity for us to hear from public defense leaders about their experiences in implementing public defense reform and using ILS funding to do so. And this year I invited Susan Lettis from Otsego County Public Defender, Andy Correa from Wayne County Public Defender, and Mark Funk from the Monroe County Assigned Counsel Program. And in talking to them about this meeting, I said, you know, I hope that you're honest about what the successes are, but also the challenges. And I also invited them to talk to this board about what additional support ILS can provide them that would really facilitate their efforts. And so I'm going to start with Susan from Otsego County. So thank you, Susan.
I'm Susan Lettis from Otsego County. I'm the public defender there. I took this position 1 year ago, so last November is when I started. So I'm new to this and I've sort of been brought up to speed through the last year and learned a lot. Our office has 13 people in it. We have 3 full-time criminal defenders, if you include myself. 3 part-time criminal court attorneys, and then also 2 full-time family court attorneys. We have support staff, we have a grant administrator, we have a new data officer or data specialist, or excuse me, discovery data specialist, civil service skills, and some support staff. So we have maybe it's a small office, but it's pretty big for where we are. I've really enjoyed actually coming to the office and learning about, you know, the funding that's available through ILS. Our county was a county that didn't take full advantage of all the funding that was available, and I don't know for certain, but I suspect it's just because it takes a lot of time and effort to actually create positions and recruit and figure out how to implement, you know, changes in an office and figure out how to convince the county, you know, board members why this is a good idea. So I think Otsego has come a long way. And right now our board is very supportive of our department. And I think it's 100% because of the support that we get from ILS. So we definitely wouldn't have all the positions we have if we didn't have the state funding. It's not that our county didn't want to support our department, but they're trying to cut places all the time. So they're always they always have financial issues. So one of the challenges is that I found is just all the different things that we have to do. As leading the office, we wear many different hats, and so we're stretched in a lot of different places. We carry a caseload. We're expected to do everything, and so that's been one of my challenges. But I've also found it really rewarding and really interesting, and actually a little fun. I've gotten a lot of support from my main contact, Catherine at ILS, and she's been very helpful with just troubleshooting things and figuring out different ways, different approaches. We've been able to do some modifications of our ILS brands to make some adjustments that would work better for our office. So this past year, we were able to have private investigators under the contract. We've had a couple of social workers that we've been able to bring into cases when needed. And so that's been helpful. And, we hope that we can do more of that in the future. We've been really lucky, I guess, with hiring. So when I started, we created a couple new full-time attorney positions and we were able to fill them pretty quickly. And I think it's because we had very competitive salaries compared to other parts of the state. And so I think that is very helpful. But even with that, it took a lot of time to put, into recruiting and, calling people, making connections and stuff. So I'm glad that, we're fully staffed now and, I just hope to keep creating more positions and hire more people. But let's see, I made a couple notes just to make sure I didn't forget anything. From what I understand, the reimbursements have gotten better. So I wasn't around before, so I don't know, but, with the new, I call it HH2, it's reimbursements are a little bit easier, figuring out fringe benefits, for example, that was something that was a little bit more tricky. Now it's a lot more straightforward. I was able to report to my parent committee yesterday, that, our revenue line in my budget line is basically where it was projected to be. So that was kind of a big deal. That's never happened before in our budget. And I think it's because of the modifications that we were allowed to do, to make some adjustments to use the funding more. So that was helpful. I do, not that it's directly related to, ILS, but it's come up today and that's internships. So one thing that our office has done is created, like internships, which we didn't do before, that I know of anyway. But we've had 3 interns so far within the last year, and 2 out of the 3 said that they wanted to return. And so we're, trying to, continue recruitment through these internship programs. We had an intern from Northeastern who's just finishing up. They have a really nice co-op program that we're involved with. We are able to tell our interns that we have a practice order, and so they can actually go to court with an attorney and, do real attorney work. And so I think that's a plus. And we'll definitely look into the internship line next time.
I think it's.
Yes. But housing is important, in Cooperstown is a tourist town, and so sometimes housing is really tricky, but we've been thinking about it, like how it would be helpful to have like a rental available to some interns. So we could at least give them a place to live. So I think I'm happy to answer any questions, but those are my main.
Do you want to just touch really briefly on the Gideon's Promise?
Oh, sure, yeah. Yeah, so we were able, with ILS funding, we were able to have the director of Gideon's Promise and one of her staff people come and do a training with us. It was a training for our whole office, and it was actually to create a mission and vision statement. Before coming to my position, I had never thought about a PD office having a vision and a mission statement. I just didn't think of it that way, but it's very clear to me now why that's important. And it really helped sort of, we had our training out of the office, we were gone all day, weren't thinking about work. So we were separated and we were able to really think about what we're doing and why we're doing it. And we involved the whole team because I really wanted to make sure everybody understood they were, everybody's a part of it. And everybody's has an important role to play. So that was very, very helpful. And so thank you.
Well, and that's, Susan talked a little bit about not fully spending ILS funding. And so she had unspent funding on a contract and reached out and proposed that we extend the contract with designating that funding to be for this project. So it's that type of creativity on not only using, funding available in current contracts, but thinking about how to repurpose unspent funding from previous contracts to really facilitate the mission. So when you suggested that, I was, yes. And it was a good day.
Yeah, it was good. And we had that training, you posted that training for, the PD leadership and
Yeah.
assigned council program coordinators. And so I already had sort of gone through that, but I wanted to bring it back to the office. And it was really helpful to have Gideon's Promise do that for us and call them professionals.
And when Susan says you, she means ILS, and who she really means, and I need to give a shout out to Claire Committal and Claire Zakarian of our chief defender, or our criminal defense representation unit that really were the brain people for the Gideon's Promise leadership training, which was spectacular.
Yeah.
So,
I'd say that for someone who's been in a position a year, to find your feet in that position and also expand and move in new directions is really impressive. Great work.
I have supportive people. I have a great team in the office and ILS is there supporting us. And so, and I like it.
so that was a little bit of my criteria for who to invite is crazy people who.
Yeah.
And having said that, I'm going to turn to Heavy for now.
Needs no further introduction. So this crazy person is actually thrilled to be here to talk about Wayne County with the board. I appreciate the time. So let me tell you a little bit about Wayne County. Wayne County has about 93,000 people. I call it semi-rural with an emphasis on agricultural. We have no cities in Wayne County. There's more counties than you would think in New York State that don't have any cities in them at all. We have 18 town and village courts. They're almost all lay judges. And we have 3 county court judges who handle everything, multi-part benches. We handle only criminal cases. We come into contact with about 2,000 criminal cases a year. We conflict between 20 and 25% of them to our ECP. We have 22 total positions in our office now, 24 if you count our paid summer intern position that we have in our HH line, and a constant rotation of MSW interns coordinated by our social worker in our office. And we are squeezed into our renovative office space. Mr. DeVolt, I understand what you are saying. And as of this moment, we are fully staffed, which has been a Herculean effort on multiple fronts, which I describe as everything, everywhere, all at once. So, say that and knock on wood. So, I want to just rattle off some, I would call them accomplishments or things that worked out, perhaps as a more accurate description. And then I've got 2 stories to tell you that will be brief, hopefully, and then a couple of observations at the end. So basically, what has the funding done for us? All of the funding, the distributions, the CAFA, the HH money. So fundamentally, we've added the staffing that met the expectations of the agreements with ILS that began way back in 2011, 2012 with the initial distributions. We raised grades and salaries for most of our non-union positions in the office. The recent push took time. It took 3 years, and I don't mind saying that it involved protracted political complications to make that go through. I heard periodically, you have money, good for you. It's impossible or difficult to upend the existing equal structure of salaries without causing some issues. And I understand all of that and we've worked our way through it. We are now competitive, I would call it, at least in our region. We created a mitigation team made up of a social worker, a social work assistant, and our first assistant is also a JD MSW who is the supervisory head of the mitigation team. We added a part-time investigator position, and they educated us, our full-time investigator and our part-time investigator, who were experienced investigators. They told me the tools that they needed that we didn't have, and I could provide them to them because of this funding. We have a generation of lawyers on staff that will never know what it's like to have to go without an expert to consult. Revolutionary. I can send these lawyers to national, state, high quality, expensive training for staff development as needed. And I don't mean just the lawyers, everybody else too. And because in the end, I can talk to a committee and say at no county cost. Now they still have a skin in the game, but that is the original county commitment to this work. But the HH money is what's driving that. I have the ability to pay for organizational memberships for almost any organization that the lawyers in my office want to join. especially, and I just sign up a full office membership every year with NYSDA. And full disclosure, I'm the secretary of the board of directors on NYSDA. And because of our staffing, I do have the time to play a small role with all of the varied and important work that NYSDA does, including, we already heard about the recruitment and retention, there's the discovery forensic unit, there's the public defender backup, there's the legislative work. I mean, it's an unending list, and PDCMS and cloud storage with this discovery, these things that we could not operate our office on a day-to-day basis without that organization backing us up. And then an absolute revolution in how we handle our appellate practice, again, led by our first assistant, Kim Duguay, who has turned us into an aggressive, thoughtful appellate practice that is brand new work in our office, really. I don't mind saying that Kim has set me straight about how to do appeals and the need to do appeals, and we have money to outsource the appellate work that we now require to represent our clients effectively. And it just so happens that we're on the cutting edge of some developing law in the Fourth Department. And these days there is plenty of developing law to be had. So, first story. To reflect a little bit on how far we've come, I want to take you back briefly to 1995. So in 1995, a 17-year-old young woman walked into Lyons Village Court charged with a misdemeanor for endangering welfare of a child. The charge involved her 7-year-old niece, who was apparently walking down the street unattended when she was supposed to be keeping an eye on her. This 17-year-old girl walked into court without a lawyer. The judge accepted a guilty plea on a misdemeanor, endangering welfare of a child, with no DA and no public defender in the room, sentenced her to a fine, and she left court thinking it was over. Well, guess what? YO was also mandatory, youthful offender, which would have sealed the conviction from public view. And that was not granted or even discussed, for what I can tell. There were notes on a court file that I eventually saw recently that had 2 lines in it: pleaded guilty, fine. No file was ever opened in the public defender office. No one else knew anything about it. So now fast forward to a couple of months ago when a 46-year-old woman walks into the building where my office is and happens to run into our county administrator, Rick House. Rick House gets the gist of why she's there. He calls me on my cell. I go down, meet her and her teen daughter, bring her into my office. I find out very rapidly what happened in 1995. And she tells me about the 2 jobs that she's lost over the many years because of this outstanding conviction. She tells me about this business startup loan that was denied because she had this conviction. She tells me that she was just hired for a job, but now the background check has come through, and now her job is hanging in the balance. All due to this 1995 conviction that we don't have any record of. So, small miracles here. I chased down the records from the court. And why is that tricky? Because the Lyons Village Court doesn't exist anymore. And now it's been absorbed by Lyons Town Court. And the same clerk, though, over the years, so that was helpful. She finds the records. She immediately recognizes the problem because we've been able to work with her over the years to acclimate her to things that are expected on the defense side. Turns out I have the right DA, too. We agree. We put it back on the calendar for an oral CPL 440 motion to first vacate the sentence and then an agreed upon dismissal. It's dismissed and sealed, but it's not over yet. The clerk has to call DCJS and figure out how to deal with the fact that the record is from a court that no longer exists and actually get it out of the system, which she does. And now I am confident that at least in New York, this conviction is sealed and gone. I do have this pessimistic streak of 27 years as a public defender. I have to recognize that the FBI may still be aware of this conviction if they haven't done what they're supposed to do. I mean, hopefully they have, right? It should be automatic, right? I know I'm in your wheelhouse right now. But I can't help but shake the feeling that after all these years that something else is going to happen.
Actually, the private ones.
Yeah, right.
But anyway.
So anyway, what's the point of this? The point is that when this was all said and done, how far have we come? I cannot fathom how that would happen today. We are there. We're in the room. That's the first thing. CAPA, CAP, all the things that we do now, we're there. Judges and clerks, they know better now. Judges in my county are aware and afraid to take pleas on misdemeanors because they know they should not be doing that. Even the lay judges in all these town courts, they are aware. It's hard for me to see how this would happen. Ignoring youthful offender? Never. That would never happen now. I say that with some level of confidence. And you know, if this had happened today, a 17-year-old woman that walks into Lyons Town Court now, she would never be alone the way this person was alone in 1995. So that's an improvement. So next story. I mean, this is a story really about unintended consequences of this implementation of all of these things, the limited resources that we can sometimes have in our area to meet the challenge, and then local government challenges really that we have to hurdle to get these things done. I had to laugh when I started thinking about this. I thought back to Law Day 2011 when Judge Lippman announced that there would be counsel at first appearance within a year, which was bold. That was bold. And so then I'll skip ahead to 2016 in Park County. So 5 years later, we started a counsel at first appearance project on call, only at 6 out of our 18 justice courts, using CAFA 2 money, then CAFA 3 money, and eventually some HH money to compensate the lawyers who were going out into the world in the middle of the night. Then by April 1st of 2019, we started a centralized arraignment at the Wayne County Jail, twice a day, every day, 365 days a year, now paid for by CAFA 4. But by 2021, we knew we had an unanticipated problem. People were being marooned at our Wayne County Jail, which was the location of the centralized arraignment part. And they would be dropped off at the jail, sit for some number of hours, see the judge. Even to today, we're batting about 80% of our clients that go through the centralized arraignment get out, either on ROR or on pretrial release conditions. But then we had somebody that law enforcement is no longer responsible for transporting, stuck at the jail. And sometimes even on snowy days on Route 31, which is a highway in Wayne County, they get pushed out the door. That was a problem. So the first thing I did, you know, they have no family, friends, no money, no bus, no reliable taxis. So I talked to the local bus system. That took a month or two to work through. It's not their fault, but the bus system in Wayne County, which is rectangular, is basically a circle within a rectangle. There's no way that they could accommodate an unknown amount of rides from the jail a few times a month. So that was a dead end. So then you have to confront, are there services in the county that would even be appropriate to engage, and how do you engage them? By contract. It would have to be by contract somehow. If it's going to be more than $5,000 in my county, it has to be either out to quotes or out to bid. There aren't even enough services really to go to bid. So you have to dig up the services that you'd like to contract with. So we found a local taxi service that had just popped up. The county attorney was an ally here. I mean, the county attorney saw the liability issues of somebody being pushed out the door from CAP in the middle of the night. And insurance requirements for contractors. This company that we were talking to couldn't meet those requirements. Again, after many months of wrangling, we were back to square one. Now, serendipity, I'm in a Zoom meeting about a year into this process of trying to solve this problem, a Zoom meeting with the county DSS and aging and youth departments. They had been contracted by a company called Go Grandparents, which is not the kind of name that would pop into my mind about the way to solve my problem here. But after talking to them, it became clear that they're an agency that coordinates with ride-sharing services in your area. They can provide you with a dashboard. They can provide you with a way to track rides, and a way to provide you with invoices. And basically, they pay the ride-sharing people, and then we pay Go Grandparents for their services and for the rides. Now, eventually, we did our own contract with them. I kept it under $5,000 so I didn't have to get quotes or go to bid. It was $4,400 was the first contract we did with them. The second contract we did with them is $4,900 now. We're able to understand that this doesn't always happen at the cap, but this service needs to be there for when it does. So we also have tentatively expanded these ride opportunities to, and it all has to be cleared through me, I have to approve it, but emergency rides for clients, and this is like, when you're practicing, you realize there are times when you absolutely have to speak to a client, no matter what. And sometimes it has to be face-to-face. Talking about a plea bargain, the final decision, the big decision, yes or no, we have to decide. That's got to be in person. They have to be in front of you. Court appearances that absolutely cannot be missed. The opportunity to make an agreement, go down and finalize a plea that the client wants that's favorable to them, or even trial preparation has to happen. So we do have these other criteria to provide rides. We do not have the resources to be ride sharing services for all of our clients, for all things, but we have these list of things that we can do. So the point of this story is unintended consequences from the existence of the cap and limited resources in our community make this a 3-year process for a contract that a small contract, in my world, a very small contract, for something that everybody wanted that solved an obvious problem. And this is not a story about a county obstructing. This is a story about a county trying to implement, and we have to follow their procedures to do it in a county that doesn't have a lot of options to get this done. And, you know, all along the line, I know that the folks at ILS were intrigued by this idea. They asked a lot of questions about it. Were rooting for us to figure it out. And eventually we got there. And I guess the question I'm left with is, what would this have been like in a county that was not inclined to help? Even this small thing that took hours and hours over 3 years to get done. So I guess the last thing I want to talk about is independence as a public defender in a county. And the question is, do I have independence? I think the only truthful answer is sort of. I sort of have the illusion of independence. I think it's a constructed independence. It's constructed in the sense that previous Wayne County public defenders have earned the locals' respect. So I was able to build upon that. I'm only the 4th public defender ever in Wayne County in 58 years. And there has been a strong presence in the office long before I got here. And that helps me tremendously. Together, working with the ILS staff who's been willing to interface with our administrative team, I think we have a good working relationship. And of course, the funding, these funded mandates that the county has accepted exist, allows me to maneuver without really obstruction, just the normal complexity of our county government. So, for example, we were one of the earliest counties to sign off on the Hurl Herring contract. I think it was the first wave of the HH contracts that went through that we were on board with that. And I think that was due in part to the work with the distributions and CAFA, like demonstrating to the county that this will work, this will make a difference, and the money will come in from the state. But, oh, and I told my fiscal assistant that I would mention his name too. Brian Sams is our fiscal assistant that I've spent a lot of time working this out, and him educating me about how these budgets can work in the context of a county budget. So, but I am not making any mistake here. My illusion of independence is largely dependent on personal relationships and trust that has been built up over time. This coming year, well, this year, half of our board of supervisors turned over. So there was a whole new batch of members of the board of supervisors, which, you know, I had to kind of go back to the drawing board as far as education is concerned about our complicated funding to maintain this constructed independence. Next year, it's likely that a lot of our administrative team is going to move on. That's really important to me because we forged this really trusting working relationship. And, you know, we'll start again. Always raises concern about how that will go. And again, I guess I just want to say again, I don't know how it works in counties where the local government is either completely understaffed or disinterested or somehow dead set against the rollout of these things. I hope I never find out because I can't imagine how hard it would be it's challenging enough to find ways when a county is trying to play ball and actually trying to comply within the rules applicable to all the other departments, because we cannot simply upset the entire structure of the county because we have funding. We have to find a way within the existing system. So just two more quick points. Patricia and I we had a quick conversation at breakfast this morning about what we could ask of ILS. And I did say, don't overlook the structure, the infrastructure that needs to be created to facilitate the documentation necessary for reimbursement requests. That is something that I think we learned the hard way, because my confidential assistant basically over the last 12 years has turned into a self-taught accountant. But we were able to get some of that work off of her desk by funding half of a position in our treasurer's office to help us compile what we needed to do timely reimbursements. So that's really one thing. And the second thing is, everybody knows that just because you're good at a certain task doesn't mean you're going to be good at managing the office that does those tasks. I was very fortunate that I had my confidential assistant that knew how to handle these things, and she's still there. Probably won't be for much longer, which is terrifying, but I don't know if there's a way to have this outreach with new public defenders to do an in-depth discussion about structuring budgets. I know all the documents are out there and they're on the website, but there's just something about being able to sit down with a team in a public defender office to prepare them for the onslaught of what is about to occur when they take that position purely financially. I think that would be something to really consider. And I'm just going to throw this out there, the very last thing I'm going to say. I've been thinking lately, I'm proud of all these accomplishments and things that have worked out, but I don't know if anybody ever asked themselves, I'm sure you do, I'm asking myself today, is it possible to meet our goals here in the ILS mandates in a county-based system? And I'm not really looking for an answer. That is today, I don't have an answer. That is something that I think about all the time, whether this is going to work the way it's wired to work. Thank you.
Thanks, Andy. Andy had shared with me the story of the 17-year-old. And I had a similar type of case before I worked at ILS at CCA. And I was so proud of myself that I got the YO adjudication. And I loved it when Andy shared his story, because he was like, I wasn't going for the YO, I'm going for outright dismissal. But I say that, but I also don't want to diminish the importance of the last question that Andy had, because I think that's an important question for all of us. I'd like to now turn it over to Mark Funk. Mark is the Monroe County Assigned Counsel Program Administrator. Recently, before that, he was the Monroe County Conflict Defender that also oversaw the Assigned Counsel Program. So Mark has played a very critical role in untethering his Assigned Counsel Program from the Conflict Defender Office. So Mark?
Good afternoon, everyone. So I want to say I was a past chair of the Chief Defenders Association. I'm very glad that James is our current president. I'm also the current chair of the Chief Defenders Family Court Committee. And I want to talk about family court in a few minutes. But I do want to talk about Monroe County and how we, the Public Defender's Office, Conflict Defender's Office, and Assigned Counsel Program have really worked cooperatively together to implement the Harrell Herring expansion into Monroe County. And Jill was a big part of that when she was at the Monroe County Public Defender's Office. We, the Assigned Counsel Program, took on some cases from the Public Defender's Office to help them meet caseloads. And it was actually Jill's job to pick the cases that would be sent over to us and then we would assign out. So I think at one point we were doing 25 cases a month or something that we were taking from the PD's office to help them implement their caseload caps. Another huge change that was allowed due to the HH funding was that the Conflict Defender's Office became the primary provider of representation in Rochester City Court, taking that responsibility from the PD's office to lighten their load some. And that was a huge change that we had. And then Patricia mentioned kind of the other really huge change that we've had since the Rural Herring implementation is the split of the Conflict Defender's Office and Assigned Counsel program. For 6.5 years, I did both jobs that really prevented me from doing a lot of new initiatives with regard to the Assigned Counsel program. Because I was in the Conflict Defender's Office with all of the assistant conflict defenders around, and those in the room, supervise folks. You got folks coming in all day long. I got this problem, I got that problem, stuff like that. So those are the immediate issues that you're dealing with. And was difficult to, oh yeah, you have to set all that aside to implement these new programs with the Assigned Counsel program. So the last 1.5 years, we have been able to focus exclusively on the Assigned Counsel program, and that has helped a great deal. But I wanted to give kudos to our current conflict defender, Sarah Holt, and Julie Sianta, our current public defender, and before that, Tim Downer was our public defender, and we've all worked cooperatively together to implement, reforms to benefit our clients. The things now I want to talk about is what we're doing to implement reforms in the Assigned Counsel program. So just after the first of the year, our resource attorney, Scott Young, will celebrate his 2-year anniversary with the county. So as a resource attorney, he's available. He's a resource for our attorneys. He's available to answer questions. He's available to help with research, to just talk about how to handle this, how to handle that. And Scott says, he's done a great job with that. It has taken some stuff off my plate. As of January 6th, we're hiring another attorney to fill a long vacant training and mentorship coordinator position. That attorney's name is Peter Polano. Between the three of us, Peter, Scott, and myself, we have over 100 years of criminal defense experience. And I'm the baby of the group. I'm a little guy at 29 years. And so they're more senior to me in that regard. We recently, in the end of March, moved into a new space. And I brought along a thing. I'll pass around some photos of our new space. We have workspaces where attorneys can come in if they need a space. We have meeting rooms where attorneys can meet with their clients. One of the photos is a conference room. It's got a big TV where we've been meeting with attorneys, and they can put up, there's so many that have videos now. They can put up their videos on the screen so we get an idea of the cases that they're working on. We're really trying to implement the new space in the best ways we can. We've implemented a second chair program. Every case that involves a death or a life sentence, not persistent, we haven't got that far with the second chair program, but any felonies where there's a life sentence on the back end has 2 attorneys involved. And that's been, I think, a really good success for our office. We're trying to get some of the younger attorneys to handle second chair matters to kind of get them some experience so they can move up into our higher panels. One program that I'm pretty excited about is that we are case conferencing cases with attorneys. I've arranged to have our Supreme and County Clerk's office send me every Monday a calendar of upcoming trials. and we reach out to the attorney, if you've got an upcoming trial, we'd like to case conference the case with you. To date, we've done about 20 case conferences, and in more than half of the cases, we've gotten complete acquittals. And in October, in a 2-week span in October, our assigned attorneys had 5 acquittals, 3 on murder cases and 2 on rape cases. And we conferenced 4 of those 5 cases. So, I think our assigned attorneys are doing a nice job, and hopefully these case conferences are helping with their representation, with their trial prep. And we've also implemented recently Westlaw for all of our panel attorneys. And the big project that we've been working on for many hours over the last year plus has been updating our website. My goal is to have our website as a one-stop shop for everything that panel attorneys need. If you're looking for an expert, we're going to have an expert database. You're looking for some information on 71030 notices, we'll have some information on 71030 notices on our website, whatever issues that are coming up. Another thing we're working on is a Giglio database because our DA's office just realized that there's actually a case from 1972 called Giglio and Brady, and they're just starting to turn stuff over, so we're trying to compile that. But we found with their implementation of giving us Giglio that what we get in one case with the same officers is not what we get in the next case and stuff like that. So we're compiling our own stuff and making that available to our panel attorneys. The biggest challenges that I'm facing as assigned counsel administrator, I think a lot of assigned counsel administrators is that our job is like herding cats. These are not institutional offices. We're dealing with attorneys in private practice, so we don't have really any authority over them. We're trying to change the culture of the assigned counsel program. Andy just said that, he's got a generation of attorneys that know what it's like to not forego an expert witness. Well, that's still something that we're trying to work with our panel attorneys, hire an expert. We unfortunately just had a case last week with a DNA matter, and the attorneys did not hire a DNA expert. And we found that out like 4 days before trial. You really need to do that. So it's really a change in culture that we're working on. Another big hurdle that we're having is just communication with our attorneys. In so many things, we're trying to implement these new services, the Westlaw. We now make Westlaw available to everybody. I think we've announced it in emails, a newsletter, and I'll send around a copy of a newsletter that we do. We do it not quite monthly because we're finding out that our attorneys are not reading them. So we've kind of cut back a little bit. We're doing it like kind of every other month. Our first one was in March, and I had an attorney tell me in August that, I just read your newsletter from March. I go, okay, but that's an issue regarding communication. So we're sending out emails and newsletters with, we have these services available to you. Take advantage of them, and we're still getting folks, I didn't know you had that service. I didn't know this was available to me, and things like that. And the case conferencing is another thing that we're trying to publicize. So we just had a staff member make up a little postcard that we're going to be mailing out to panel attorneys. So with regard to communication, we're trying to do like both old school stuff and new school stuff. We're trying to do the old school, an actual postcard. Here, get something in the mail and you look at it. There's a lot of times, and I've had attorneys tell me this, I send out so many emails to them, they just delete them. And hopefully they get something in their hand and they can, and we're working on a brochure with all the services that we provide. And then we're talking about social media, I've been a little leery of social media, especially with that Supreme Court case from earlier this year. But so we're trying to figure out how to do social media in a smart way to get the word out to our attorneys. Another big challenge is that our family court attorneys are completely shut out of all of these reforms because the HH funding can only be used for criminal matters. And that's, a huge issue. And I know our family court attorneys, I think, feel neglected. Earlier this year, we did like our first annual meeting of the panel, and it was, like an hour 15-minute meeting, and they spent like 5 minutes on family court. And that's, but that's another thing that we're just trying to do is to, with regard to communication, is just get people in the same room together. So I'm planning another annual meeting in January. We started about 6 months ago doing monthly happy hours just to get folks together. Next week, we're having a office holiday party. You're all invited if you want to come to Rochester. In this photo, there's a nice little area in our office with like a little love seat and some chairs and stuff like that we're going to be doing round table discussion, just picking a legal topic, get people together, get them in there to talk about it. That was an idea I got from Ben Bonarigo from the Genesee County Assigned Counsel Program. And I think that's one great thing that NYSDA does and that ILS does is they have done a great job to get chief defenders together in the same room to talk about what each county is doing. So I'm stealing ideas, and I'm happy to say I'm stealing ideas from other folks to try to make our panel better. The last thing I do want to mention is family court. The family policing system, we reject the calling it the child welfare system, the family policing system. And frankly, the family court public defense system in New York is a miserable failure. The former Chief Judge's Commission on Parental Representation noted that 12% of court proceedings where children are removed from their parents, there was no lawyer representing the parents. The most recent Office of Children and Family Services statistics are that after children are in 3 years, and had cases pending for 3 years in family court, that only 50% of their children are reunited with their parents. Statistics like that are horrible, and we really need to improve the family court system. Over the last 5 years, there have been 5 major reports on how bad things are in family court. And I do want to thank the Chief Judge for all his support and leadership and, and creating this new task force to look at ways to improve family court and ILS for its work in, distributing the meager funds that we are getting family court. But the Chief Defender's Office, our Chief Defenders Association, has estimated that it's about $220 million necessary to fully implement reforms in family court as we're doing in the Hurrell Heron and the criminal side. And what did we get last year? 14 million or 19 million or something like that. So like a tenth of what we actually need to address the problem. So that needs to be addressed. And I know I'm preaching to the choir here about it, but I thought it's important to bring it out. And I do want to note that with ILS funding, the good work that's being done in Monroe County, our Monroe County Public Defender's Office was one of the first counties to receive a large family defense grant. They were able to hire 4 attorneys and 4 social workers, and they're actually able to represent their clients and litigate cases. They're actually having 1027 or 1028 hearings. they're actually having fact-finding hearings or disposition hearings. And frankly, that was pretty unheard of prior to that grant. And the Conflict Defender's Office has received a smaller grant that has allowed them to hire one attorney and one social worker. And again, they're doing, they're litigating cases, which is what we're supposed to be doing. And that was not possible without ILS funding. So we greatly appreciate that. And hopefully the governor and the legislature will see the light and give us more than 10% of the funding that we actually need going forward in family court.
Thank you. Does anybody have questions for either Mark or Andy?
Just a quick one, and maybe it's more for you, I don't know, forgive my ignorance, but Mark was talking about how these ideas are shared in meetings that you hold, and I'm wondering, we've heard about the Gideon's, meeting with your office and the transportation, and Mark describing these meeting spaces, so now attorneys will actually not just be meeting in the Hall of Justice with their clients, and Mark describing some of the other innovations. And I'm wondering, is there some place where this is shared in a newsletter or list for those who don't make the meetings?
We're working on that.
She's looking at me.
It's like Tina's actually talking.
Yeah, we've been talking a lot about it. I think it's, for so long, we've been sort of under the obligation to create reports.
Mhm.
And so we've been really sort of limited to having to really focus on the reports, the intended use of the reports and what they're supposed to sort of talk about. But I think we're moving to a place where we can actually start to produce more information in a more useful way, like that. So I love that suggestion. And, I'm hopeful to, that we will be able to start making that kind of information more easily accessible too, like on our website and in other places. In addition to the teams sort of being out and providing it on a one-on-one basis. So,
It's so exciting to hear about these things.
yeah. Thank you.
I want to give Mark more work, but the framing you had, I think, could be very useful in convincing the governor to include something about increased monies for family representation in her state address. So if you could, I can't memorize everything you said, but if you would distill what you had, the framing I'm talking about is, but we're not hearing money is, let us, do the following things. And here's the results of that. We don't have any of that in family court. Here are the gaps in family court. If we had money for these things, just as a case study from Monmouth County, I think, I could send that off to the governor, right? And
Absolutely.
use that as a push.
Absolutely. Family court reforms are like my pet project that I'm very adamant about, so.
I mean, the legislature's given us more judges,
Right.
but that's only a piece, right? It's work for different lawyers and other systems.
And even in family court there, I mean, we were talking about changing our culture of our assigned attorneys and stuff. Family court needs a change in culture in where the judges make no bones about it. I'm not giving you a 1027 hearing. I'm not giving you a 1028 hearing. It's a waste of my time to actually hold hearings. Or when we do hold hearings, you take an hour worth of testimony, then they adjourn the case for a month. Then you take 2 hours of testimony, gets adjourned for another month, where literally trials last for a year and you get like 6 hours worth of testimony in a year.
I'm trying to see if we can, at least in some of the bigger places, not only in New York City, I mean, outside of New York City, create trial courts.
Some judges are 2 and 3 handlers, right? They have dockets, county court, circuit court, family court dockets.
Right, and
Judges are both.
in those counties, it makes it even worse because, they only do like family court 1 day a week or something like that. So if you're supposed to have a hearing, you can't cut in on your county court time or, absolutely.
I was just in Columbia County and they have enough volume to have full-time family court judge. They don't have them, so they've got multi-headers, they've got somebody else coming in. And the AJ was there with me, he said, well, where would you put the full-time family court judge? Jeff Space, 6. You're getting off topic, you're getting. Those are from-
Ready for Bert?
Ready to burn.
Okay. Relatively brief ILS office updates this quarter. I do want to thank our administrative officer, Christine Becker, for pulling together this information for me to share with all of you. We are currently in the process of onboarding 2 staff members. One just started earlier this week, Julia Shaw, who is a special assistant for mitigation with our statewide appellate support center. And then we will have an appellate attorney with the statewide appellate support center who will be joining us in January. We also have an offer that is currently out that we hope to be formally accepted very soon for an assistant counsel with our family representation unit in Albany. We have 2 positions where offers have been accepted and they're currently making their way through what's known as the BDA process to fully onboard them. One is a grants administrator who will be providing administrative support for our growing grants unit, and then a criminal defense representation counsel with Nora's team covering Region D, which is sort of the North Country Adirondacks area of the state. We will be posting very soon for a handful of positions that we'll need to fill. One is for a litigation resource attorney with our statewide appellate support center. One is for a family court counsel in our Western New York Regional Support Center office. And then 3 newly created grants unit positions that we're going to be posting and filling for an assistant grants manager 1, a contract manager, and an additional auditor. So all of that will bolster the work that the grants unit does. You met Tammy Smith at our last meeting. They'll be providing Tammy and the rest of the team with quite a bit of support. So that's the update from the ILS office.
Reminder of the 2025 board meeting dates are on your agenda. So April 4th, June 13th, September 19th, and December 12th.
Unless anybody has any notes, we're adjourned. Thank you.
Thank you, everybody.
Happy holidays.